Public Records 8038. Public records activities of the office or agency, no restrictions against criminal and trial matters observed pursuant to legal duties, exclude matters observed by police officers in criminal cases, factual findings relating to an investigation, factual findings including opinions. To determine whether the sources of information or other circumstances are untrustworthy, it has to be shown by an opponent that it is untrustworthy. In timeliness of investigation, skills or experience of the official, whether a formal hearing was held on the level it was conducted, not required but suggested by advisory comment notes. Possible motivational problems. Declarant unavailable. Declarant is unavailable, and you have to prove that the declarant is unavailable, and only if the statement is one of the exceptions. Definition of unavailability is claim of privilege, refusal to testify, lack of memory, death, illness, infirmity, or unavoidable absence. The former testimony exception, 804b1, is only need the opportunity to cross-examine, and there has been a similar motive to cross-examine in the previous hearing. Example, if there was a trial from the same facts previously. Motive means there was reason to cross-examine in the previous case. Dying declarations, 804b2. Statement under belief of impending death, personal knowledge of the cause of circumstances of what declarant believed to be impending death is required. What declarant believed to be impending death is required. Only in civil cases, but allows this in homicide, criminal cases. So not other types of criminal cases. Declarations against interest. Not the same thing as party admission. 804b3, statement against interest, not the same thing as party admission. Statement that was at the time of its making so far contrary to the declarant's pecuniary, proprietary, or penal interests, or so far tended to subject the declarants to civil or criminal liability to render invalid claim by the declarant against, and that a reasonable person in the declarant's position would not have made the statement unless believing it to be true. Alrighty, so the three elements of statement against interest are unavailable, against interest, and any witness or party can make it. Statement of party opponent, three elements are statements by, then the second element is by opponent, and the third element can be self-serving or against interest. Declarations against interest in a criminal case. In a criminal case, a statement tending to expose the declarant to criminal liability is admissible in the following circumstances only if offered to exculpate, vindicate of crime, and accused of it is supported by corroborating circumstances that clearly indicate its trustworthiness. If offered to inculpate, charge with crime, and accused, it is supported by particularized guarantees of trustworthiness. Forfeiture exception is a 104A decision, meaning the judge makes the decision. Forfeiture exception is 1. Statement by a party that wrongfully caused the declarant's unavailability. 2. Intended to make declarant unavailable. And 3. Party actually made the declarant unavailable. Wrongly caused the declarant's unavailability. Intended to make it unavailable. And actually made the declarant unavailable. Speaker seeking to Factors to look to prove the trustworthiness of a statement. Speaker seeking to curry favor. Spontaneity of the statement. Relationship of the accused. Credibility of the speaker. Was Mirandized. Suggests no pressure to speak. Corroboration. The catch-all exception, 807. Texas doesn't adopt this catch-all because it leads to uncertainty of admissibility of evidence. So the residual exception, not covered by other exceptions, 1, and then 2, have circumstantial guarantees of trustworthiness. 3, offered as evidence of material fact. 4, more probative on the point for which it is offered than any other evidence which the proponent can procure through reasonable efforts. 5, more probative than other evidence, justice concerns. And 6, has to notify other side in advance to allow rebuttal. Attacking and supporting credibility of declarant, 807 Crawford v. Washington, 2004. Crawford rule, where testimonial evidence is issue, the Sixth Amendment demands what the common law required. 1, unavailability, and, conjunctively, 2, a prior opportunity for cross-examination. 911 call was not testimonial, therefore admissible. Is a police report admissible? It is. Is a police report testimonial? It is testimonial, therefore not admissible. Example, police interrogation. Character evidence not admissible to prove conduct. Exceptions, 404. Character evidence, generally evidence of person's character or a trait of character, is not admissible for the purpose of proving action in conformity therewith or on particular occasion, except character of accused, character of alleged victim, character of witness, other crimes, wrongs, acts. Character of accused. The defendant can evidence of own pertinent created to the action of the case, trait, or character. Defendant can offer evidence to support his own character and rebuttal. 404A, bring for good relevance, good character relevance. Character alleged victim. Evidence of pertinent trait of the character of the alleged victim is offered by defendant or by the prosecution to rebut the attack on the victim's character, or evidence of the character trait of peacefulness of the alleged victim offered by the prosecution in a homicide case to rebut evidence that victim was first aggressor. Character of witness, offered to impeach a witness, testifying witness entitled to show that the witness has a character of untruthfulness and acting in that truthfulness by lying to the witness's stand. 404, character and issue, use, conduct, crimes, other wrongs, acts, proof of motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake, accident. 404B, can't use character to show action, can't use prior robbery to show defendant did this robbery. Character to prove conduct or a particular occasion. 405. 404A2, offered by accused to make the accused, and the accused can make pertinent character trait of verbal victim at trial about assault. So this is pertinent trait, aggressiveness to start a fight. Evidence can be a form of an opinion, reputation when allowed by 404. 405 only allows it for specific instances of conduct on cross-examination. Don't allow specific instances of conduct on direct, only reputation or opinion. 404B, character issue. Character in issue can use specific instances of conduct or character or trait of the character as an essential element to the charge, claim, or defense under the substantive law. Character as an element of a charge, claim, or defense. only have to prove the element or current crime, 404B exceptions. Prior acts of proof, motive, intent, play, and relevant points, 404B. Other crimes, wrongs, or acts may be other inferences that can be drawn from the character evidence. Example, prior acts to show motives, prior act to show modus operandi, MO to show identity, prior act to show the character, show knowledge. Proving intent, identity, modus operandi, pattern or method of operation of crime, plan, design, other purposes, proving prior act. Habit, routine, practice. 406, habit, routine, practice. 104A problem, that means the judge. Evidence of the habit of a person or of the routine practice of an organization, whether corroborated or not, and regardless of the presence of eyewitnesses. Hypothetical is picking up your mail at a certain time, that is a habit. Being punctual, that is a character trait. So picking up your mail at a certain time, that is habit. Being punctual is a character trait. And it's a 104A question. The three elements of habit are subconscious, regularity, and specific. Remedial measures, 407. Subsequent remedial measures, 407, when after injury or harm allegedly caused by an event, measures that are taken, if taken previously, would have made the injury harm less likely to occur. Evidence of the subsequent is not admissible to prove. Exception to remedial measures, only if brought up by a defendant party for feasibility. Settlement negotiations, civil settlements, to prove liability for invalidity of claim or its amounts. 408, compromise and offers compromise, furnishing or offering, promising to furnish or to acceptance, or offering, promising to accept valuable consideration in compromising or attempting to compromise a claim which was disputed as to either validity or amount, is not admissible. Civil settlements exception with a public entity. Civil settlements are not usually admissible in criminal cases unless you settle with a public entity. 409, payment of medical or similar expenses. Evidence of furnishing or offering to furnish or promising to pay medical, hospital, or similar expenses occasioned by injury is not admissible to prove liability for the injury. So no exclusion for the surrounding statements to settle at the time you agreed to pay the medical bills. Inadmissibility of pleas, plea discussion, and related statements. An offer to plead guilty is not admissible to show guilt. A plea of guilty which was later withdrawn, a plea of nolo contendere, any statement made in the course of a proceeding under federal rules of criminal procedure. Liability insurance, evidence that a person was or was not insured against liability is not admissible upon the issue of whether a person acted negligently or otherwise. Competency of a witness. Competency of witness was severely limited by common law. General rule of competency supplies the rule that every person is competent to be a witness except otherwise provided in these rules. However, in civil actions proceeding with respect to an element, the claim defense of the state law supplies the rule of decision. The competency of a witness shall be determined in accordance with state law. Competency versus personal knowledge. 104A. Question for the court to decide by preponderance of the evidence the competency of a witness in an issue for a trial judge. But personal knowledge is an issue for the jury to decide. 104B. 612. Writing used to refresh memory. If a witness uses a writing to refresh memory for the purpose of testifying, either 1, while testifying, or 2, while before testifying, the court in its discretion determines it is necessary in the interest of justice, an adverse party is entitled to have the writing produced at the hearing to inspect it, to cross-examine the witness thereon, and to introduce evidence, these portions which related to the testimony of the witness. 612.2, work product, says there is a presumption that work product will not come in, but the trial court in their discretion can allow the documents to come in. Necessity will bring it in if demonstrated by a party. By other party. Exclusion of witness sequestration. 615. 615. Exclusion of witness. At request of a party, the court shall order the witness excluded so that they cannot hear the testimony of other witnesses, and it may make the order of its own motion. 4 categories of witnesses are not included in the criminal rule. Natural persons represented. 1, natural persons representative of the party, essential to the 3, essential to the presence of the cause, and 4, person authorized by statute to be there. Impeachment of witness. 5 ways of impeachment. 1, bias. 2, defect in perception or memory. 3, prior inconsistent statements. 4, contradicting the witness. And 5, untruthful person by disposition. That can be shown through non-conviction, misconduct, cross-examining, and character witness. Evidence of character and conduct of witness. 608. Evidence, opinion, and reputation of evidence character. The credibility of a witness may be attacked or supported by evidence in the form of opinion or reputation, but subject to limitations. Opinion, limitation of opinion, reputation. 608. The evidence may refer to the character for truthfulness, and evidence of truthful character is admissible only after the character witness for the truthfulness has been attacked by opinion or reputation evidence or otherwise. Bias and motivation. Bias is always probative and relevant. Bias is never collateral. 608B, cannot use extrinsic evidence to show witness conduct to impeach witness. Bias is not limited to 608 approach. Impeachment, sensory and mental capacity, showing witness couldn't hear or see enough to remember or remembrance condition. Character, truth, veracity, impeachment, cross-examination, non-conviction, criminal act, 609 balancing, and character, witness, reputation. Alrighty, 702 Daubert rule. 5 criteria from Daubert for expert witness. 1. Can it be tested? Falsifiability. 2. Peer review, publication. 3. Known or potential rates of error. 4. Standards governing techniques, operation, general acceptance. That's hearsay flashcards.